Welcome back to Media 7. We're talking suppression orders with Warren Young and Val Sim of the Law Commission and Metro Magazine editor Bevan Rapson. Perhaps we could have a look at the video now. It's a case I find quite interesting. Let's have a look at this now. This is the Timaru lady.
I've decided to speak out because so many of our politicians are lying to you about the case where the Timaru mum disciplined her son with a cane and on a later occasion with a riding crop. I'm fed up with the media lies that have been published about this. I have never ever beaten any of my children. I've disciplined them appropriately when they have needed it. I looked for the cane and I couldn't see it, and I saw the riding crop on the windowsill, so I used that to discipline my son. I held him by his arm and I struck him 2 or 3 times on his bottom with the riding crop. This is a riding crop here, and my son actually said he preferred to be disciplined with the riding crop as it didn't hurt as much as the cane had.
The Timaru lady. Now, Val, I'm interested in this case because that woman got herself, you know, she's all over YouTube. She got herself on 3 News with that. She was able to pretty much campaign, and yet she can't be named. Is that an example of where a suppression order is counterproductive?
I think the answer would very much depend on why the suppression order was made and what interest was being protected when the suppression order was made. It may be, for example, that the order was made to protect the interests of the child.
Which was the case.
And if that was the case, then notwithstanding the fact that the woman has chosen to go public, it would seem that the child still should continue to be protected.
So the child's interests are paramount, and we just have to live with that.
Yes,
That's
but if it had been a circumstance where the order was made on the basis of some claimed hardship to the woman herself, then there might well be a case for saying that order should be set aside because she's chosen to put herself in the public arena.
So who would actually go to a judge and ask for that order to be set aside, if that was the case?
I think the media would probably have standing to make that application.
Mm-hmm. Bevan, you were talking about the celebrity drug case, but before the break, people who are well known would, at least their lawyers, would make the case to a court that these people have much more to lose from being, exposed in public, and therefore deserve name suppression more than ordinary members of the public who no one will know who they are. What do you make of that argument?
I don't buy that at all, Russell. I think when people have a public profile and identity, there's a whole package that goes with that. One side of the package is everyone treating you like you're special and giving you entry to things that you wouldn't otherwise get entry to, and being highly paid and getting a lot of adulation. And one part of the other side is that should you ever appear in court, chances are people are going to make something of it. And I mean, I guess the young 14-year-olds wondering about a professional rugby career, maybe they should be informed of that fact early on. I'm sure they are, actually.
Yeah, we'll actually be talking about that later in the show.
Right. So, I mean, it's just part of the package, and the idea that some kind of fame thing should be taken into account in court, I think that's silly. I think you can't allow something like that to overrule the basic principle of open justice. And I would just like to say that even in the most innocuous case, even when it's just a JP doing it for 2 or 3 days or whatever, every time there is a name suppressed, I think that it undermines people's faith in the justice system, because people out there go, oh, how did they get that hushed up? There's something going on. The people if you get the right lawyer, you're able to get things hushed up, is the perception that spreads every time there's a suppression, I believe. So, I think the judges and the lawyers should bear that in mind every time that they bring a suppression order down.
What do you make of that, Warren?
I'm not sure that I totally agree, Bevan. I certainly agree that if name suppression has been granted to people who have reputations to lose as a matter of routine, then that undermines faith in the system. But I think whether or not people who are well known get suppression depends very much on what you regard as an appropriate ground of suppression. If you regard undue hardship as a ground for suppression in some circumstances, albeit limited, hardship to that person or to their family, even if it's for a short period, then that's inevitably going to work more in favour with people with a lot to lose than people with nothing to lose. At one end of the spectrum, you've got somebody who may have just come out of prison, who's been there for 5 years and who has 60 previous convictions, where there's going to be no hardship from suppression, from publication rather, because no hardship to them could possibly arise from that. Whereas somebody who actually is a member of a profession with a strong community reputation, who's charged with an offence, who hasn't had time yet to tell their relatives about it, who hasn't had time to tell their employees about it, who has a business still to run for the next week. Those
That
all
always
might be
gets me.
things.
The I haven't had time to tell anyone thing always seems to buy them 2 or 3 days, as far as I can tell. I mean, have they not heard of a telephone?
Well, and that's why some jurisdictions actually do have a standard 7-day period of suppression that's pretty well routine. After that, very difficult to get it at all, but you have an interim period to enable people to tidy up their business affairs, tell their elderly grandmother that's dying of cancer and all those
Yes,
other
they
things
always
that
are.
people raise. But those are actually things that it's very difficult for a judge to assess when somebody's been arrested the night before. And so certainly one of the things we're exploring is whether it ought to be easier for people to get suppression for a very short period at the beginning. And that makes it very much more difficult for people then to sustain the argument.
Do you
after
think it's
7
also
days.
important, Val, for people to understand what's going on in these cases? Because I think Bevan has a good point. I think there is a part of the public that whose odium grows every time they see a suppression order granted, and they don't know why. A judge perhaps hasn't justified it. Is it important to actually justify that to the public?
Yes, I'd certainly say that where a name suppression order is granted, judgments ought to make it entirely clear on what basis those orders are granted, and also for how long they're granted, because, as Warren said, sometimes it can be a very short period, just to give time to tidy up affairs, sometimes particularly where the reason for the suppression is to protect the right to a fair trial. The order lasts until the trial, but then there's a question of what happens if the trial doesn't take place for some reason. So should it have a finite date? And then sometimes, of course, they're made a permanent name suppression order that lasts forever. So I think it's very important both that the terms of the order are made very clear and that the reasons for the order are made very clear.
Now, I was interested in the paper that there's a couple of grounds for suppression that are very long-standing, that you've quite strongly recommended be done away with, including protecting the public morality, which suggests that the system is responsive to social change. I mean, we're not going to be outraged and have a fit of the vapours if we read a disturbing case in the paper, are we? Is that what it's about?
Well, certainly that ground does seem to be antiquated, and it's very difficult to see why the public shouldn't have a right to know facts simply because it might upset people or the facts of the case be contrary to public morals. Arguably, it actually educates people about morals to know the way people are behaving contrary to social values. So I think that's certainly a ground that should go.
And you've also recommended that we do away with the idea of, say, particularly, I imagine this will apply in sexual crimes, to do with the reputation of the victim. We are not going to assume that a victim is a loose woman because she,
Well, exactly, but one of the problems at the moment is that victims of sexual offences are singled out for special treatment in this regard. Their names are suppressed, other victims aren't. And certainly there's a strong body of opinion amongst victim support groups, for example, that there ought to be pretty routine suppression of the names of all victims, unless there's a public interest in having it published for some reason.
which I suspect is something Bevan's not going to like. You don't like not being able to report things, do you?
No, that's right. And I mean, you can immediately think of cases in which there's a victim in a case, and maybe there is someone out there who knows that this person is has a history of being a victim in this particular way, or of false accusations or whatever, and is able to come forward and come through the back of the court and take the stand and have an effect on the case. So
there are potentially situations where you'll have that story and you won't be able to report it because of a suppression order.
That's right. Well, I think just getting the name out there, the reporting of it is what we want to do, of course, but I think for the system, it is extremely healthy to have all the information out there that we can possibly have, and the little bit of benefit that accrues to the person who's had their name covered up is pretty minor compared to the overall benefit to society to having all that information out there.
Now, you're privileged, as a journalist in court. You may even be allowed to stay in the courtroom when the court's closed, and there are quite good reasons for that being permitted. What happens in the modern age where you might not actually know who the journalists are? If someone turns up and says, I'm a respectable blogger, do they get to stay in the courtroom?
At the moment, the Act talks about an accredited journalist, but it's not very clear who accredits and how and on what basis. And clearly there's a need to look at how one can distinguish between a journalist who's someone who does it by way of occupation, but also is subject to a code of ethics, a complaints process, and the other things that provide some protection against inappropriate standards when
Well, good luck
unravelling
unravelling that, because none of us can work out whether we're journalists either.
Well, the same issue actually arises if there's a register of suppression orders, which is one of the issues that the Ministry of Justice is looking at with the media at the moment, because clearly actually one of the ways of making sure that the media know what is suppressed or not is having a central register they can go to. But of course, if you have a central register, you need to define who it is who can have access to it. If everyone had access to it, it would defeat the purpose of the suppression order.
Yeah, exactly.
So how do we know who can go and who can't? The family court do have procedures for that at the moment that I think seem to work pretty well.
We've certainly had at least one submission saying that expresses some discontent with the family court process and suggests the Evidence Act definition, but that's really designed around protecting confidential sources, and I'm not sure would necessarily work in this context.
So clearly there are some tricky issues. What's the time frame in actually getting something back out of this report? Submissions have closed. When do you actually expect to have a result?
We expect to have a final report completed by around about the middle of the year, late June, early July.
Well, perhaps we'll touch base with you then. Thank you to all of you, and you too, Bevan, for sticking up for the media. After the break, we'll be back with a new panel looking at a group of media figures for whom suppression is sometimes a controversial issue, the errant sportsmen.